Is it worth contesting a will? Contesting a will can be financially and emotionally taxing. That's why it's important to understand the viability of your claims, how long your case may take, and how much it's going to cost. Because each will contest is different, the costs of challenging a will vary depending on the specific circumstances of your case. However, most contests will cost tens and potentially even hundreds of thousands of dollars in legal fees. Whether it's going to be worth it to contest a will depends on factors like how large the disputed estate is, how many others will share in that estate, the value of the assets you stand to recover, what's your share, how sound your arguments are challenging the will's validity, the time and costs that you'll need to invest in your case. An experienced estate litigation attorney can assess these factors and help you decide if the potential benefits of contesting the will are worth that emotional and financial toll. What reasons exist to contest a will? You can't contest a will simply because you don't like what it says. Instead, to successfully dispute a will, you're going to need to have legal grounds to challenge its validity. Here are some of the most common reasons. 1. The legal formalities that were required to be followed when creating the will weren't followed. So for a will to be legally enforceable, the person who made it has to follow specific legal formalities required under each state's law. The particular specifications will vary from state to state, but everyone who creates a will usually has to adhere to at least the following requirements. First, the person making the will has to be of legal age. Second, the person making the will has to have testamentary intent, which simply means that they want the document to serve as their will. Additionally, in order to verify the document's validity, the person usually has to sign it in front of a couple witnesses. Some states require more. And the witnesses must sign the will as well, affirming that it is what it says it is, a will. However, there is an exception to these witness and signature requirements for handwritten wills, if someone basically just writes a will in their own handwriting. 2, lack of testamentary capacity. For a will to be valid, the person who made it has to have what's known as testamentary capacity. This means that they had to have sufficient mental awareness and acuity to comprehend 3 fundamental concepts. First, the extent of their estate, what they owned. Second, that they're creating a will. And then third, who's going to take those assets. 3, undue influence. Another common reason to contest a will is undue influence, where the person executing the will did not create it of their own free will. Instead, they were compelled to make the will or name someone as a beneficiary when they wouldn't have otherwise done so if they had been doing it freely of their own free will. 4, fraud. Fraudulent wills also can be contested. This includes forged and otherwise fraudulent will documents, as well as wills that were executed through fraud. For example, if a fraudster tricked someone into signing a will by telling them that it was a different document, then the will could be challenged as a fraudulently induced will. Who pays legal costs when contesting a will? Usually the person contesting a will is responsible for paying legal costs. However, a successful challenger might be able to get reimbursed for those litigation costs from the estate's assets in some certain circumstances. In probate litigation, each side of a dispute generally is responsible for its own attorney's fees. The person who initiates a will contest might also be able to recover court filing fees and other expenses. However, and depending on the law in your state, you may be able to request reimbursement of those expenses from the estate funds if you can show that your actions benefited the estate or a class of beneficiaries. An experienced probate litigation attorney can help you navigate these issues as well as the will contest process and help you decide whether this is a process that you want to undertake. Have questions? Give us a call or shoot us an email anytime. The consultation is always free. Thanks for watching.